Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Rhysa and today I'll be taking you through false imprisonment. My colleague Aaron has already taken you through what battery and assault are, and today we are going to be discussing what false imprisonment in the law of tort is. False imprisonment in the law of tort is a situation which occurs where a person has been intentionally restrained or confined in a particular place, no matter how long or short, without a lawful or justifiable excuse. That is the dictionary meaning of what false imprisonment in the law of tort is. However, Sarkodie in the case of Appiah and Mensah defined false imprisonment, and he stated that false imprisonment is a complete deprivation of liberty for any time, however short, so long as it is without lawful excuse. That is the definition of false imprisonment in the law of torts, specifically within the Ghanaian context. Under the 1992 Constitution of Ghana, there are certain provisions of which false imprisonment relates to. Article 14(1) of our Constitution guarantees the personal liberty of all persons within the country. However, it gives certain circumstances or instances where someone can be restrained and it will be permitted under the law. However, if someone has been falsely imprisoned, what it means is that the person was not restrained under any of those circumstances. Article 21 of our Constitution also talks about the general freedoms all persons have, which include the freedom of movement and association. So, if you are a law student and you are presented with a factual situation of which false imprisonment relates, you must make sure to make reference to Articles 14 and 21 of our Constitution, because these provisions are what talks about the personal liberty of all persons, and it also guarantees the freedom every person in the country has. For false imprisonment, there's a particular case which in law is considered as a locus that you must always have in mind, and this case is a case of Warner and Rutherford. In Warner and Rutherford, the courts gave the necessary elements that must be established for false imprisonment to have been said to have happened. What the court stated is that for false imprisonment, there must be restraint. The restraint must be total or complete, and it must be unlawful or without a justifiable excuse. So, once again, the person must be restrained, the restraint must be total or complete, and it must be without a lawful excuse. What Warner and Rutherford have told us is that if someone has been locked in a room which has 2 doors and the person wants to step out, if another individual locks both of these doors without giving the person any means of escape, that means the person has been falsely imprisoned. However, in that same scenario, if someone locks one door and the back door has been left opened, that means that the person has not been restrained completely or totally, and thus the restraint is partial. If the restraint is partial, the individual that has been restrained cannot be found to say that he has been falsely imprisoned. It does not meet the criteria under the case of Warner and Rutherford, and that was established in the case of Baird and Jones. In Baird and Jones, the facts are simple. There was a boat race competition, and the organizers had blocked one part of the road, but had left the other side for people to use. When the plaintiff was on the road, he insisted on using the road that has been blocked, but he was not permitted. And eventually he was not pleased, and he brought an action in court alleging that he had been falsely imprisoned. However, the court stated that even though he was restrained, the restraint was partial and not total, because he still had another side of the rules he could have driven off or used. So, in that case, the necessary elements of false imprisonment was not established. One thing to note under false imprisonment is that even if you have been restrained and you have been given a means of escape, but if you use that means, it will amount to an injury to you, or it is not a safe means of escape or a reasonable one, the action of false imprisonment will succeed. For instance, if you have been locked in a room on the second floor, there is only one entrance and you have been locked, but the windows are open. If you are to use the window to step out, even though they are open and you can't use them, it is likely that when you do use those windows, you are going to injure yourself. So in that case, you can actually bring an action of false imprisonment against a person who kept you in that room. Because even though there's a means of escape, the means of escape is unsafe and unreasonable, and it is one that when you use, it is likely to injure you. That was seen in the case of Wright and Wilson. In Wright and Wilson, the courts established that if there's a means of escape which is reasonable, you cannot bring an action for false imprisonment. However, if it is unreasonable for you to use it, or it is one that when you use it, you are likely to get hurt, then the action for false imprisonment will suffice. For false imprisonment, it does not matter how long or short you are kept in the room. As Sarkodie J stated in Appiah and Mensah, if you are kept for a second and it is without a lawful excuse, your action for false imprisonment will succeed in a court of law. For false imprisonment, merely failing to facilitate the departure of a person from one place to another will not amount to false imprisonment. For instance, if you are in a moving vehicle and it has not gotten to a bus stop, but you tell your driver that you want to alight, and your driver insists that he is not going to drop you off unless we get to the bus stop, you cannot say that the statements your driver made to you amounted to a complete restraint of your person, and it was without a lawful excuse, and thus you are bringing an action of false imprisonment against him. Because when you do that, it will not work. The case of Head and Weardale Steel speaks directly to this particular principle in law. And the facts of this case are very simple. There was a miner who wanted to be brought to the surface after breaching agreement to work underground for a specific duration. And his managers refused because it was not yet time for him to be brought to the surface. He was not pleased with it, and he brought an action in court alleging that he had been falsely imprisoned. The courts did not agree with him, and his action failed because the courts found that the mere failure of his managers from departing from one place to another will not amount to false imprisonment. However, one thing you should know under false imprisonment is that if you detain someone to enable the person to enforce a particular contractual duty, what you have done will amount to false imprisonment. For instance, if you are a medical doctor and a patient comes to your hospital and you treat the patient, after treatment, if you give the bills to the patient and the patient is unable to pay, and you inform the patient that because you have failed to pay, I am not going to release you, and you hold the patient for about 4 hours, that particular 4-hour period within which you held that patient will amount to false imprisonment. The case of Samboff and Alford addresses this particular principle under false imprisonment. In this case, the plaintiff could not pay the bills he owed to the restaurant after eating, and the defendant told him that if he fails to pay, he's going to detain him, and he withheld his coat as security for payment. He actually did do that, and the plaintiff was not pleased with it. After the plaintiff succeeded in getting out of the restaurant, he initiated an action against the defendant, alleging that he had been falsely imprisoned. And the courts agreed with him that indeed you cannot falsely imprison someone under the guise of enforcing a contractual duty. The courts frowns upon those actions people do take. When it comes to false imprisonment, the knowledge of the plaintiff is something that the courts have considered from time to time. And there are two schools of thought which addresses this particular concept. The first school of thought believes that for an action of false imprisonment to succeed, the plaintiff must have been aware that he had been restrained without a justifiable excuse. That was seen in the case of Herring and Boyle. In Herring and Boyle, the plaintiff's mother was not allowed to pick him up from school after they had vacated because the school was stating that the lady owed them an amount of money. The plaintiff was later released upon a writ of habeas corpus and taken home by the mother. The mother was not pleased with this and she initiated an action against the school, alleging that her child had been falsely imprisoned. However, from the facts we had, it was established that the plaintiff apparently was enjoying himself while on the school compound when all his colleagues had gone home for the holidays, and he was treated well. He was not even aware that he had been falsely imprisoned. So when the lady initiated the action, her action failed in a court of law because in the opinion of the court, the plaintiff, which was Herring, was not aware that he had been falsely imprisoned. And what is necessary for false imprisonment is that you must know that he had been restrained without a justifiable excuse. The other school of thought, which talks about the knowledge of the plaintiff or the victim, is the one that says that it does not matter that the plaintiff was not aware. What matters is that the plaintiff was restrained totally without a lawful excuse. They believe that the plaintiff's knowledge of it is not of consequence to the matter. And that is what we have in the case of Mearing and Graham White Aviation Co. In that case, the court stated that knowledge of the restraint at the time is not necessary to succeed in an action for false imprisonment. The mere invitation, therefore, by the policeman to the plaintiff to enter a waiting room while the policeman remained outside constitutes arrest and false imprisonment. So to them, it does not matter that the plaintiff was not aware that he had been restrained totally without a justifiable excuse. The case of Murray and Minister of Defense also supports the principle as established in the case of Mearing and Graham White Aviation Co. In that case, the defendant and 5 soldiers entered the room. They detained, searched, and arrested the plaintiff without a warrant upon suspicion of aiding the IRA. So the defendant arrived at 7 and formally arrested the plaintiff, and he was done at 7:30 a.m. after assembling and identifying the house occupants. The plaintiff was released at 9:35 a.m. after being interviewed, and she claimed damages for false imprisonment and trespass. What the court stated was that it is not an essential element of the tort of false imprisonment that the victim should be aware of the fact of denial of liberty. Where a person is detained by a police officer and knew that they were being detained, that amounted to an arrest, even though no formal words of arrest were spoken by the officer. The failure to make the formal arrest until half an hour after entering the house did not render the plaintiff's detention from 7 a.m. unlawful, and under the circumstances of the case, it was reasonable for the defendant to delay formally arresting the plaintiff until the defendant had taken the necessary steps to assemble all the members in the house in one room and to search the house. So the court agreed with the principle established in the Mearing and Graham White Aviation Co. that indeed the knowledge of the plaintiff does not matter when the person has been restrained unlawfully without a justifiable excuse. In Ghana, Article 14.5 of our 1992 Constitution states that any person who is unlawfully arrested, restricted, or detained by any other person shall be entitled to compensation, therefore, from that other person. What this means is that for Ghana, we are treating the issue of knowledge of the restraint as something that amounts to an award on the plaintiff's part. Because Article 14(5) of our Constitution is stating that if you have been unlawfully arrested, restricted, or detained, you shall be compensated by the person who caused it on you. So if you are aware that this has happened to you, you are entitled to be compensated under the laws of Ghana. Another constitutional provision that you should have in mind when it comes to false imprisonment is found in Article 14, Clause 3 of our Constitution. And it reads, any person who is arrested, restricted, or detained, A, for the purpose of bringing him before a court in execution of an order of a court, or B, upon reasonable suspicion of his having committed or being about to commit a criminal offense under the laws of Ghana, and who is not released, shall be brought before a court within 48 hours after the arrest, restriction, or detention. Article 14, Clause 4 goes on to say that where a person arrested, restricted, or detained under paragraph A or B of the Clause 3 of this article is not tried within a reasonable time, then, without prejudice to any further proceedings that may be brought against him, he shall be released either unconditionally or upon reasonable conditions, including in particular conditions reasonably necessary to ensure that he appears at a later date for trial or for proceedings preliminary to trial. The relevance of this provision to false imprisonment is that when a person has been arrested by the police, that person must be kept in police custody for a period not exceeding 48 hours unless that individual has been released. And if the person has not been released, that person must be brought before the court within that 48 hours. So if a policeman arrests you and he detains you for 49 hours, the particular hour that has been added to the 48 hours will amount to false imprisonment, because you have been detained and you have been restrained totally without a lawful or justifiable excuse. Under false imprisonment, because Article 14, Clause 5 of our Constitution states that whoever arrests, restricts, or detains someone, that particular person that has been arrested, restricted, or detained is entitled to be compensated. What this means is that it is necessary for the individual to find out who actually caused his arrest or detainment. In the case of Onogen and Leventis, the issue of false imprisonment came up. The facts are that the defendant informed police of 72 cases of Heineken in his store which had been lost, and it was a plaintiff who was in charge of the drinkables in that particular shop. When he informed the police, the plaintiff was detained for 26 hours before being granted bail. The plaintiff was prosecuted, and after the whole process, he was subsequently acquitted, and he sued for false imprisonment, wrongful dismissal, and malicious prosecution. The court held that no false imprisonment can be held against a company because it was the defendant's agent who made the complaint to the police. They did not authorize, demand, or request for the plaintiff to be arrested. So the action could not have succeeded against the defendant's company. When it comes to false imprisonment, it is important that if a person makes a complaint to the police station, if the police decides to act on their own discretion without being authorized by any other person, you cannot initiate the action against the person who made the complaint to the police station. The person was merely exercising his civic duty, and it is the police that actually caused your arrest and detainment. However, if the person authorizes the police to cause the arrest of a person, and it later comes out that the person was unlawfully arrested and falsely imprisoned, the action of false imprisonment should be initiated against the individual who authorized the arrest of the particular person, who in this case is likely to be the plaintiff. and that was seen in the case of Amaje and Opokuwari. In Amaje and Opokuwari, there were two policemen who were patrolling, and they were informed of unlawful meeting by the appellants and that they should be arrested. The respondents appeared on the scene when the police were interviewing the appellants and ordered their arrests. The facts of the case disclosed that the policemen were acting upon the authorization by the respondents of the appellant's arrest. And based on that authorization, the policemen caused their arrest and unlawful detention. The court held that the respondents made false complaints against the appellant, and the complaint was made recklessly without any justifiable excuse. Besides, they also authorized the police to act. So in that case, the action of false imprisonment was properly initiated against the respondents. They were the ones who authorized or caused the arrest of the persons. Another thing when it comes to false imprisonment is that if you are merely assisting a police officer in the performance of his duties, it will not amount to false imprisonment. That was what was seen in the case of Nkrumah and Foley. And in that case, the defendant pointed out the person the police were seeking to arrest to the police officer. And it was the police officer who eventually went to initiate the arrest. So the plaintiff initiated the action against the defendant, alleging that his action caused his unlawful arrest and false imprisonment. But the court stated that merely assisting the police or accompanying them to point out a particular person is not an initiation or instigation of the arrest, and therefore it cannot hold a ground for a case for false imprisonment. That is because the defendant was merely assisting the policeman in the performance of his duties. However, for the case of Musa and Limo Wulana, the court also stated that an action for false imprisonment will lie against a particular person if it is found that that person gave a false information which caused the police to arrest the person and also resulted in him being unlawfully arrested and falsely imprisoned. If you give wrongful information to the police and it causes the police to arrest a particular person, and in court it comes out that the person was not found guilty of the offense he has been alleged to have been committed, that individual can bring an action against you for unlawful arrest and false imprisonment. That is what we have seen in the case of Musa and Limo Wulana. The case of Yao and Bekwe also supports the principle as established in Musa and Limo Wulana. That brings us to an end on our discussion on false imprisonment. We have discussed what false imprisonment is, and we defined it as per Sarkodie in the case of Appiah and Mensah. We also established that for false imprisonment, there must be restraint. The restraint must be total or complete, and it must be without a justifiable excuse. We have also established that false imprisonment, some people think that the knowledge of the plaintiff of his restraint is important for the action to succeed. And the other people also think that it does not matter that the plaintiff was not aware that he had been completely restrained. We also know that if you authorize a police officer to unlawfully arrest someone and the police officer acts based on your authorization, an action of false imprisonment can be initiated against you. Thank you for joining us in this wonderful session. Kindly do not forget to like, comment, subscribe, and share our video to your friends and viewers for them to understand what false imprisonment under the law of tort is about.